Today we're going to talk about hearsay. Hearsay as it applies in the legal definition. There's a great deal of confusion about what exactly hearsay is in the legal context. This is true not only of lay people, but even attorneys sometimes have difficulty with the concept of hearsay. Part of the problem arises from the fact that hearsay does have a general definition in the English language. The Merriam-Webster dictionary defines hearsay simply as rumor. I sometimes like to think of it as something like scuttlebutt. In any case, none of this has anything to do with the legal definition of hearsay, and you're only going to confuse yourself if you continue to use the term hearsay in a way that doesn't have a legal application. Often I have clients who I will be discussing a case with, and they will say to me,
"Everything that officer wrote in his report is hearsay."
Now it turns out that my client is right, but not probably for the reason that he thinks. It's not because it's unreliable or inaccurate inherently. It's because of the legal definition of hearsay. And that, in and of itself, the fact that the police's statement is hearsay, is not particularly useful to us. This is because nearly everything that we say or write, in fact that any of us say or write, is almost always hearsay from a legal perspective. In the Colorado courts, hearsay is generally defined as is a statement, either oral, written, or as a communicative gesture, made by someone who is not currently testifying in order to prove the matter asserted. As a general rule, hearsay is not admissible in court. However, there are two major caveats to this. First, the definition I gave of legal hearsay is not exhaustive, and there will be certain types of communication which are not defined as hearsay. Second, there are more than 28 exceptions to the admission of hearsay in court. So even if something is hearsay, legally speaking, there are at least 28 different ways that it potentially may come in. In the case of my client complaining about a police report, well, it certainly is an out-of-court statement because the officer is writing it not under oath in a court. And secondly, it certainly is purporting to be the truth. That is, the officer's statement is supposed to be a record of what really happened. So the officer's statement, then, meets the legal definition of hearsay. But the more important question is, so what? Is this statement going to come in at some hearing at some point? Any potential witness in any court hearing has only spoken hearsay until they take the stand to testify. And at that point, at the point that they're on the stand testifying, is the only point when they are not speaking hearsay, unless they're trying to say what someone else or something else said, and then they have a hearsay problem. And even then, just because it's hearsay doesn't mean that a court is not going to consider that. As I said, there are 28 ways at least to get hearsay in before a court. Normally, hearsay is addressed over several sessions in a course dedicated to the rules of evidence in law school. So it's impossible to go through every exception to the hearsay rule in a brief guide like this. However, hopefully now you understand that hearsay is much more complex than the lay term of rumor. And there is a more fundamental question that it brings up. Is this statement going to be considered at trial as evidence of something? For example, will this doctor's note be admitted? Or will the hotel's guest book be admitted as evidence? Can this woman testify to what she overhears another couple arguing about in court? Every one of those examples is hearsay. And yet, probably, each one of them can come in and be considered by a court as to who wins or loses a case. It's my hope that this general conversation about hearsay illuminated some things for you and helped you better understand exactly what hearsay means when we're talking about it within a legal context.